Humanitarian Appeal between an application of DM Rwanda and Secretary of State for the Home Department.
Right, Mr. Tam.
Please recall. I'll start with a bit of housekeeping as a result of things that were asked for overnight and the argument yesterday. The court should have a small clip of documents, which I'm going to make a suggestion as to how they're filed. On the top of it is a two-page note that we have prepared about the Section 72 argument. Can I suggest that that goes in the front of the additional authorities bundle, the supplementary authorities bundle, simply for convenience because it's hole punched, and that's a good place for it. And then the rest of it is some tabs of additional materials we can just drop into the end of the bundle. It's tabs, the tab numbers are 6 to 10. But in fact, there's only material in the first four of those additional tabs. When you're done, I'll just show you.
You'll send all this electronically, won't you?
Yes, we'll arrange for that to be done. I know there's administrative work that needs to be done to make that happen.
Yeah, of course. But
Yes. And it's from both sides, so we'll liaise to make this.
yes, well, we've already received the extra authorities from the appellant, for which much thanks. Mr. Vanderman eventually remembered how to organise it.
Can I just show the court? Just wait a second. At tab 6, there is the Scottish case of Cadder. We're grateful to Lord Keeper for having drawn our attention to that yesterday, and there will be little that I need to say on that. Tab 7 is some copies of two sections of two statutes, but we've put them all together into one tab. It's section 33 of the Anti-Terrorism, Crime and Security Act 2001, and also section 55 of the Immigration, Asylum and Nationality Act 2006. I'll show you the relevance of that shortly. At tab 8, there is the section of the 2002 Act, which deals with deportation orders not being made until the appeal is finally concluded. And then at tab 9, there are three extracts from textbooks in response from learned friends to the court's request yesterday. Can I go back to the beginning of the bundle, as it were, to the note on section 72? Because I want to spend as little time as I can, please, on this, but there are some things that I need to say. As we set out at the beginning of the note, the proposition that Lord Wilson put to me is that the three categories of refugee that are set out in section 72 are the only three categories of refugee who can be regarded as a danger to the community and so on. And we've set out here 6 reasons why that reading of section 72, we say, would be, with respect, erroneous. First of all, the issue in question is whether the refugee is a danger to the community. The second, I'm just going to highlight these because some of this will be familiar. The second is that section 72 is a procedural provision. It doesn't say that the refugee is a danger to the community. It just makes procedural provision for how that question is to be dealt with.
Well, I wonder whether it's simply a procedural provision. It creates a presumption, doesn't it?
It does, but the presumption is rebuttable. So this is a question of how either the Secretary of State or the tribunal is going to determine the actual issue, which is he or is he not a danger to the community? And that's why we describe this as procedural. And of course, at 3, we accept that if the refugee does not fall into one of those categories, then the procedural provisions don't apply. So there's no presumption and there's no special approach in the tribunal hearing. But the proposition, we say, would go further than that, because it would mean that by its silence, Section 72 has provided that a refugee who does not fall into one of those 3 categories is conclusively prescribed not to be a danger to the community. And we say that that is quite a leap to achieve by silence. It does not naturally follow from the silence in a statutory provision which is all about procedure. At 5, I refer to the submission I made yesterday about what happens if a 2-year sentence is suspended for reasons other than to do with a danger or unconnected to the offence. And that would be an odd result if you go, the suspension for that reason turns you from being somebody who is presumed to be a danger to somebody who's conclusively prescribed not to be a danger to the community. But the additional submission that we make is that at number 6, which is that there is an interaction between this and section 33 of the 2001 Act. And for this, I do need to ask you to go to tab 7 in this bundle, and I'll show you why we say this. This is 2001, so it's a year before section 72. This section, I don't think that there was any predecessor like it, so it may well have been the template for section 72. This section 33, 2001 Act, applied to an asylum appeal before SIAC if the Secretary of State certified that the appellant is not entitled to the protection of 33.1 because either Article 1F or Article 33.2 applies to him, and the removal of the appellant would be conducive to the public good. And you see it at 3, 4, and 5, there are procedural provisions about considering the certificate. So that's why we say it may have been a template for Section 72. The point is that Section 33 applied to all 33.2 cases, regardless of whether the individual would later be considered to fall into one of the 3 categories. And so it applies across the whole generality of Article 33.2 cases. Now, in 2002, so the following year, when Section 72 is enacted, if it had the effect that my Lord put to me as a proposition, it would mean that there are a large number of categories of individual to whom Article 33.2 could no longer apply, i.e. 33.2 only applies if you're in one of the 3 categories. And therefore, in every other circumstance, Article 33.2 cannot apply. And that would mean that by the enaction of Section 72, a chunk was taken out of Section 33. But the reality was that Section 33 continued in force. If you go on to the next sheet, you'll see what Section 33 looked like after the 2002 Act was enacted. Because what was done under the 2002 Act was that some technical amendments were made to the references to the rights of appeal, but there was no other substantive amendment made to Section 33. And that means that for this reason, if the proposition were correct, these 2 sections would have been in conflict from 2002 onwards. And that conflict could only be reconciled by regarding Section 33 as having been impliedly partially repealed by the 2002 Act. Now, I don't say that that's impossible, but that's actually quite an odd way of going about it. And then towards the end of tab 7, what you do see is that in 2006, Parliament actually expressly legislated, and in Section 55 of the 2006 Act, it replaced Section 33 of the 2001 Act with this new provision, Section 55, and this was then limited to national security cases. So from that point onwards, there isn't even an arguable conflict. But it's that 4-year period in between where if the proposition were correct, then you could only reconcile those 2 sections by what it would be an unusual legislative interpretation technique. And we say that all of this really actually points to the proposition with respect being erroneous. So that's the
could you just pause one moment, please?
Slightly arcane argument, which has come rather late in the day, Mr. Chairman.
Well, Lord, it does, and the reason is because we have been working overnight just to see what we can make of this, having been put to us for the first time yesterday.
Yes, I'm sorry, my lady was...
No, I just, because you've just given us quite a lot of information, but one bit you haven't given us is what Article 1F, to which reference is made in Section 33, is...
Article 1F is a provision that excludes from the Refugee Convention altogether people who are, to summarise, undeserving of any protection from the convention. So we're talking about those war criminals, genocide perpetrators.
But we haven't got it.
No, we haven't got it in the bundles, but that's the territory that we're in. But I don't think that is relevant to this particular argument.
And just one point of detail on your first proposition in the list of 6. The issue is whether the refugee is a danger to the community.
Yes.
Yes, but it has to be having been convicted.
Yes.
Of an offence of a particular type, doesn't it?
Indeed, I accept that. One, I wrote as shortly as possible because the having been convicted, I put into the terms of the proposition above. So I'm sorry, that was sort of shorthand, but I accept that.
You need to look at 2 elements.
Oh yes, we do. And this was really to identify the issue rather than to define it, having set it out in the proposition. So those are the reasons why we respectfully say that the proposition isn't correct, and that our construction is to be preferred. But if these reasons are not enough to convince the court that we are correct on this, then we've listed a number of reasons why we respectfully say the court should not decide this in this case.
I mean, this only arises if you're right that the AIT purported to decide the matter generally and not simply confine itself to the presumption.
Indeed, and that's...
For my part, I'm not finding that quite a tricky one, so...
Yes, well, that's what we put at number 7.
Yes,
this is a subsidiary issue to a subsidiary issue in the case, and so it's really not a good vehicle.
And you tell us there's a limited amount your enthusiastic junior can do overnight, which is a fair point.
Indeed, and I'm very grateful for all the work that she has done, for the work that clients have done overnight, and we've done what we can, but this is not by any means a fully considered argument about this.
But if you're pressing the analysis of the tribunal decision as being an independent conclusion that Article 33(2) was breached, how can we avoid dealing with this point?
Well, I can see the force of that, but Lord has already expressed a view about the fact. Lord Carnwath has just
may not be pressing it very strongly.
And if the court is against us on that, then this issue falls away. And in any event, as we say in reason number 7 for not dealing with it, the legal issue, the important part of this case, is something that's got to work for DN and Draga, and so this is it's become something we've spent a lot of time on, even though it's really a very small point in the case.
But your instructions are to press ahead with the point.
Well, my instructions are that our position is that Section 72 means what we have advanced to.
No, but to press ahead with the interpretation of the AIT decision.
Yes, because there is the word further. I don't think I can...
No, I understand how you put it. It does is distracting us from some very important points in the case, which we've got to get on to.
I'm content to leave it in the court's hands as to how to deal with this. But if this interpretation point were decided against us, it has a number of effects on other things, including, in particular, the Secretary of State's published policy for the last 3 years, and probably actually longer than that as to what it means.
Well, if we concluded that the AIT did not approach it in the way that you suggest that they did, is there nevertheless an argument that you would wish to make that the proper approach to Section 72 is not to regard it as comprehensive of the circumstances in which someone can be considered a dangerous criminal?
That is your point.
Well, that is our argument,
yeah.
that the 3 categories are not exhaustive.
Right. So you're not dependent on our acceptance of your interpretation of the AIT's decision.
Yes.
The way that we have analysed it is this: if we are correct about the AIT's analysis and that they independently found that he's a danger, then I accept that this legal issue does arise. If, however, this court were to reject that interpretation and to hold that what the AIT had done was basically say, well, this is what the presumption says, so this is what we find. Everything depends on the presumptions in the 2004 order. Then this issue does not arise at all.
Because nobody else made a determination that he was dangerous.
Correct.
And even if the AIT did, you've got a slight difficulty because the original decision was not made on that basis.
Yes, although there is authority to say that even if Section 72 is not mentioned by the Secretary of State, the tribunal still has to consider it. So it's an issue.
Probably get over that point if that's your own.
Well, I just wonder about this. We've got to address Section 72 and its proper interpretation. And whether AIT addressed it properly is, to a certain extent, incidental. I mean, we've got to confront your avowed interpretation of Section 72, do we not? Irrespective of whether the AIT got it right.
I don't think we have we? I mean,
no, if the AIT got it wrong, if the AIT got it wrong, then the way that we see it is that this really doesn't matter because if our interpretation of the AIT's decision is wrong and the whole decision depends on the 2004 order, then this is entirely on all fours with Draga, and the question of whether you can be a danger to the community outside the three categories doesn't arise.
Well, I'll not prolong it, but I'm troubled by that submission. Anyway.
Lord, I think that's all I can say about that, and I hope that the note has served to record that and to make this part of the submissions a little shorter. Can I then return to the main line of the argument and the real issue in this case, the important one that has to be decided? I was submitting yesterday that despite the doctrine that has frequently been mentioned, the reality is that the courts of this country have adopted an empirical approach. They've displayed the flexibility and pragmatism that is a hallmark of the common law and fashioned individual solutions in individual circumstances when they've arisen for consideration. And Draga is exactly in that mould. Because faced with a particular set of circumstances, the court has looked at the legal context, including the statutory scheme. It has looked at principles which do underlie the common law, including, importantly, legal certainty and the finality of decided litigation. And it has looked at the consequences of the alternative solutions being proposed. And then it arrived at a solution to the problem, which is entirely logical, pragmatic, and practical. And we say that there is ample backing for that approach, and it shows why we can confidently say to this court that Draga was rightly decided and that this court should uphold it. To make all or to support all of that, can I next show the court some examples of this approach being taken?
Can I just, before you move on, just so I get it out of my mind, what's been puzzling me overnight is why no one's talked about issue estoppel. I mean, on one view, this is a perfectly straightforward case. The deportation decision is made. He challenges it by the appropriate method. He could have taken the point that the order was invalid, but he didn't. And those proceedings were finally disposed of when Mr. Justice McComb threw out the review. Now, why is that not a final determination of that issue? And how can he now, in an action for false imprisonment, reopen the same issue?
I think the reason for that is because we public lawyers have it drummed into us that issue estoppel is a private law concept.
Why? Not drummed into me.
Perhaps it needs to be drummed into Lord Carnwath.
Indeed, I won a case in the House of Lords called Thrasivulu on the basis of issue estoppel in public law. There's a whole. I was looking at Wade. There's a whole passage on. It seems to me it's perfectly straightforward. There's nothing that excludes it from public law. I mean, we don't answer it now, but I'm raising it because it seems to me that it may well be a very important issue in this case.
Yes. Well, it's obvious we have not analysed it like this. There is a long line of dicta discouraging public lawyers from saying that.
Oh,
issues
where?
are-
I mean,
Yes.
tell me, because
But
I've been in this field for 50 years.
Well, in any event, you don't rely on issue estoppel.
Well, I'm not prepared to accept that. I mean,
Yeah.
I want to know the answer to it, because when you're talking about finality, it's obviously a key point.
Well, I can say this, that when we rely on the principle of finality in litigation, decided litigation, that is actually an appeal to the same underlying concept as issue estoppel. And that's the way that in public law, this particular principle has been described or analysed. And what I will do at the end of this section is to show the court an article by Professor David Feldman, someone whose writing really does need to be taken with a great deal of respect. And these are the terms in which he describes it. It's finality in litigation. He doesn't, I think, use the words issue estoppel, possibly for the same reasons, but it is an appeal to the same broad concept, just as my appeal to remoteness in a non-technical sense also has echoes in private law. So if you look at the law of negligence, the concepts of remoteness.
Yes, let's come to it when you come to it, but I would be grateful if I've got this wrong for the last 50 years and there's something which says that issue of estoppel doesn't apply in public law. I hope someone in the court will be able to enlighten me.
Well, certainly we'll ponder that, but our argument is not far away from that. For the reason I've given.
Mr. NAFTA's is rising to the challenge, I suspect.
Yes. Three examples of this in action. The first one is Percy and Hall. Can I ask to go to that? It's Authorities 1, tab 12, MS 510. The first thing to say about this is that while the suggestion has been made that this is not a false imprisonment case but a wrongful arrest case, really this has got, that's a distinction without a difference, because the underlying tort is actually the same in both cases. The relevance of it being wrongful arrest may lie in the fact that the test or the statutory interpretation given to the power of arrest is slightly different when one is looking at the point of arrest rather than subsequent detention, but the tort is the same tort, and so the same principles apply. The interest, or part of the interest in this case, is the procedural history of the bylaws under which the arrests were made. Can I go, please, to to MS 519? It's page 933 of the report. At letter C, Lord Justice Simon Brown, as he then was, set out the history.
Sorry, page again,
It's page 933 of the report, MS 519.
Thank you.
At letter C, he refers to a prosecution for a number of breaches of the bylaws of Miss Percy and John Bugg. And then at D, that the month after, and that they were acquitted in May 91, the following month, Miss Greaves was twice arrested and sought judicial review. She attacked the validity of the bylaws on a number of different grounds. The application for leave was refused by the Divisional Court, Lord Justice Wolfe and Mr. Justice Pill, and on the particular point that was in question, the court said it wasn't arguable that the bylaws were invalid because of inadequacies in the map. And then just below letter F, in July 92, there was the Divisional Court, again Lord Justice Wolfe and Mr. Justice Pill, heard appeals by way of case stated by Mr. Bugg and Ms. Greaves because they'd been convicted, and the DPP also appealed against a dismissal of charges against Ms. Percy and Mr. Bugg. The basis of that was, you'll see at the top of the next page, that on that occasion, so just over a year later, so just over 6 months later, the Divisional Court actually came to the opposite conclusion and found the bylaws to be insufficiently certain and defective on their face in this regard. So it was an interesting procedural history, and when faced with the question of whether the claimants had been falsely arrested or falsely imprisoned, there were two issues. The first was whether the bylaws were void for uncertainty. The conclusion on that was that they were not, and that doesn't concern us. The more important part for our purposes is what if the bylaws had been void for uncertainty? And the relevant part of Lord Justice Simon Brown's judgment starts at page 943, at the top of the page. Just below letter B.
Just give us the MS number, please.
I'm sorry, so sorry, MS 529. He says, I come finally to the issue of lawful justification. And he then goes through a number of familiar authorities, DPP and Hutchinson, Hoffman and Roche, which we have. And then the first part of this section looks at the question about arrest and looks at Wills and Bowley. You see that at letter G. And comes to the conclusion on page 945, MS 531, letter B, that he saw no good reason why a Wills and Bowley construction should not be adopted. So that's the relevance of the wrongful arrest, which is that it may involve an interpretation of the arrest power to meet the context of the case. But then he goes on to ask, what then of the argument that such construction cannot avail an arresting officer whose mistake was one of law rather than fact? And in the next paragraph, he records a submission of Mr. Howell, who appeared for the defendants. Looking at the matter as at the date of these arrests, there was no mistake of law on the part of the arresting constables, certainly not in any conventional sense. It was not as if the constables had, as in the usual case, misunderstood their legal powers. On the contrary, they were enforcing what at the time appeared to be perfectly valid bylaws. To have done otherwise would seemingly have involved them in a clear breach of their duties. This essentially is Mr. Howell's second argument, and he relies on Hoffman LaRoche. The response from the claimants is set out on page 946, MS 532. But those arguments were rejected in turn by Lord Justice Simon Brown. In fact, can I just draw attention to 947 at letter B? This is MS 533. Rejecting the argument that the bylaws were defective on their face, he said, by no stretch of the imagination can these bylaws be regarded as so patently defective on their face that the constables can properly be criticised for not having identified their deficiencies and declined to enforce them. The instrument, in Lord Radcliffe's celebrated phrase in Smith and East Ello, bears no brand of invalidity upon its forehead. The same divisional court, as eventually in Bugg's case held these bylaws invalid, had, after all the previous year, regarded that very contention as unarguable. And so the conclusion that he reached at the bottom of that page It's a central question is whether these constables were acting tortiously in arresting the plaintiffs, whether instead they enjoy common law a defence of lawful justification. This question, as it seems to me, falls to be answered as at the time of the arrest complained of. Pausing there, I checked, why was that? At the time, he said, these bylaws were apparently valid. They were in law to be presumed valid. In the public interest, moreover, they needed to be enforced. It seems to me one thing to accept as readily I do, that a subsequent declaration as to their invalidity operates retrospectively to entitle a person convicted of their breach to have that conviction set aside. Quite another to hold that it transforms what, judged at the time, was to be regarded as the lawful discharge of the constable's duty into what must later be found actually tortious conduct. So here in 1997, you see exactly the same themes being considered and relied on by the Court of Appeal as was considered and relied on by the Court of Appeal in Draga. It's one thing to say that in the deportation context, your deportation can ultimately be stopped when the legal error is discovered. And that's what happened to both DN and Draga. But it's another thing to say that it then dominoes on into the false imprisonment, because when you're looking at what the individuals are doing, in this case, the police officers who had to arrest had to make a real-time decision at that point whether they were going to enforce a law which was apparently valid on its face and by law presumed to be valid. And in our case, the Secretary of State, who's making a decision to deport on the basis of a statutory instrument which had to be presumed to be valid and set out the legal framework for the making of these decisions. The two don't necessarily have to follow each other, and this is exactly the same principle being applied here.
I mean, of course, these decisions have got to be made in real time. And of course, the Secretary of State, in deciding whether to exercise the power of detention, has to see what the situation apparently is, even though later it's determined to be otherwise. But why is it unpractical to say, you took a bona fide decision, it turns out to be wrong, you've imprisoned somebody wrongly, and as a result, he has rights in domestic law, and in fact also under the European Convention, and compensation must be paid. What's the problem about that?
The problem about that is that these powers are exercised in the public interest. So detention power, which is exercised in very few cases, relatively speaking, compared to what the number of people who go through the immigration system, it is exercised to protect the public. It's to prevent people absconding and evading the immigration enforcement, and it's to prevent them from committing further offences if they are dangerous people who have a propensity to do that. So this is not the Secretary of State sort of privately saying, oh, well, I want to do this. This public interest is being served here. If the Secretary of State is always going to be at risk that at some later time, some latent defect is exposed in an earlier part of the procedure. So nothing to do with the detention decision, but a much earlier part of the chain, here the statutory instrument. And that's going to lead to what, I should say this frankly, they're very expensive claims, these, especially when some people are detained for many months or sometimes several years. First of all, it's not actually fair on the taxpayer and in whose benefit or for whose benefit these powers are being exercised. And thinking of the policy considerations which are raised in other contexts, it could lead to defensive decision-making. It could lead to a reluctance to exercise the detention power even when there is a clear call for the power to be exercised. And I'm just thinking out loud, you see some of these themes being developed in the law of negligence about whether or not public law duties being exercised for the benefit of the general public should be regarded as subject to a duty of care and negligence. And actually, immigration decisions are not, and there's been 2 Court of Appeal authorities upholding that, because these are the policy considerations that militate against them. The same things would apply here if you're asking what would be wrong with that.
Are you leaving Percy and Hall now?
No, not quite. I've got 2 more things to say. First,
I thought you might look at Lord Justice Sheeman.
Yes, I will do that. The first thing is that Lord Justice Peter Gibson simply agreed with Lord Justice Simon Brown, but Lord Justice Sheeman set out on page 951, that's MS 537, some broader observations. I won't read them all out now, but as my learned friend points out, he does posit the possibility that there might be it might be said that there should be some remedy against the person who made the unlawful administrative act or instrument. But one thing is clear. I think I can safely say this, that in English law there isn't such a cause of action, and even if one thinks that there ought to be, there isn't. There's one submission that learned friend made, which came perilously close to suggesting that this is what should be done. It was actually made in the context of the second actor theory. He says in this case, it was a Secretary of State who made the SI and the Secretary of State who detained, so it's all the Secretary of State's fault. But of course, false imprisonment isn't actually to do with fault as such. It's simply to do with, do you have a lawful justification? If you turn that question into was the Secretary of State to blame because everything that went wrong was the Secretary of State's fault, that is to start to turn this into an action for damages for unlawful administrative action. We don't have that, and we respectfully say this is certainly not the case for this court to invent such a cause of action for the first time. The traditional basis should be adhered to.
Has this been explained as a context-specific decision in any later authority?
I wouldn't like to give a definitive answer to that question. Percy and Hall has been cited in very many cases, and the one outstanding thing about it has never been overruled. Some people have questioned it, some people have tried to explain it in other ways that will occasionally express some doubt, but it's never been overruled, and it remains good law.
Well, it's all obiter, isn't it?
It is, but it's sometimes you see cases like this where somebody says, well, that must be wrong because the law is this. That's never happened to Percy and Hall. And we respectfully submit that one of the reasons for that is because when you think about what happened there, the answer is so obviously right. And these police officers, it should be said, were actually, in theory, personally liable for the damages because they did not have, for quirk in the statute, they did not have the statutory backing for, where the chief constable would be sued rather than them. So that's why the defendant is Hall and others. These were the individual police officers who were personally liable for the damages.
Well, that makes the decision. I beg your pardon. You finish.
Well, just going to say, so the answer is obviously sensible. It's
Indeed.
Obviously right.
Yeah.
The second case that I asked to
this was one of the cases that Lord Brian Wilkinson cited in the passage in Boddington, where he talked about the difficulty of this particular area of the law. I mean, he doesn't say he says a view on it, but he gives us an example of the sort of issues which need to be resolved.
Yes, and the reality is it's such a difficult problem that as a grand unified theory, it's certainly no grand unified theory has ever been successfully proposed for this, which is why I say that the solution has to be to look at every situation individually and work out what is the right thing.
There are obvious distinctions to be drawn between Percy and Hall in the present case, aren't there? Here, the constables were confronted with a law which they had no means of deciding whether or not it was valid, and as Lord Justice Simon Bryan makes clear, it was their duty to take the action that they did. Here, in contradistinction, the Secretary of State is responsible for the validity of the statutory instrument. That, it seems to me, it makes the situation quite different from Percy and Hall, does it not?
We respectfully say no, because the statutory instrument was made. I can't pretend that there was a duty to make a statutory instrument, but the Parliament certainly contemplated that the Secretary of State could make a statutory instrument. And as I showed the court yesterday, once the statutory instrument was made, it was then part of the law.
Yes, but it was incumbent on the Secretary of State to make sure that the statutory instrument complied with the law.
And for 5 years...
Which is quite different from the situation in Percy and Hall, isn't it?
Yeah. Well, for 5 years, it apparently did.
Well,
and was presumed to...
Of course, I mean, I do have that point, yes. But what I'd like you to address is the significance of the obvious distinction between the police officers in Percy and Hall and the position of the Secretary of State in this case.
Well, part of the answer to that is the one that I've just given, which is if you ask the question, or if the answer depends on was it the Secretary of State's fault or somebody else's fault, then...
I don't know that it's helpful to refer to fault. I mean, I think it's better to look at it as a question of responsibility. The responsibility of the Secretary of State was to ensure that the statutory instrument complied with the law. And, I mean, the fortuitous circumstance is that 5 years elapsed before a challenge to the validity of the statutory instrument was raised doesn't, as it seems to me at present, address the question of the distinction between the position of the constables in Percy and Hall and the position of the Secretary of State in this case.
I can say it cannot be a distinction that is determinative. It so happens in this case that the statutory instrument was made by the Secretary of State for the Home Department. But that would not necessarily be the case. In a later section of our printed case, perhaps I should deal with these points now, we do ask the question, well, what difference does it make, should it make, if the SI had been made by some other Secretary of State, or perhaps by the Lord Chancellor? The procedural rules in TN Vietnam were made by the Lord Chancellor. Does that happenstance of the parliamentary allocation of responsibility for making the SI, does that make all the difference as to whether or not an action for false imprisonment will lie? We respectfully say that that's pretty arbitrary, and it might also perhaps encourage Parliament to make sure that the power to make an SI is vested in somebody else rather than the person who then makes the decisions under it, to reduce the risk of these things going wrong. But we also say that there is an important part of this this equation, which is that there are 3 detention powers that are relevant here. And one of them depends on a court recommendation for a deportation. Court recommendations for deportations are equally subject, potentially, to challenge on public law grounds, because magistrates' courts are amenable to judicial review, as is the Crown Court in some circumstances. And so whatever solution is fashioned has got to work for all of these. And trying to pin this specifically on the identity of the maker of the statutory instrument is not likely to lead to a very satisfactory result. It could just be an arbitrary...
well, I can see the force of that, but the more obvious distinction, as it seems to be, between the constables, they are merely constables carrying out the duty that the law apparently prescribes, whereas the Secretary of State occupies a position where she must be the guardian of the validity of the laws to which she has recourse. It doesn't seem to me to be of especial significance that she was the government minister who actually introduced the statutory instrument. I mean, even if it had been the Lord Chancellor, I mean, she is responsible for ensuring that the law which she seeks to implement is valid and can authorise the action that she seeks to take.
One can obviously see that there is a route to the solution through the identity of the maker of the statutory instrument. If one takes the second actor theory literally, then one could suggest that there's some support for that.
So she's in fact the second actor, is she?
The first actor.
Well, that's
Jesus
right.
said that's the point. The second actor is a sort of the Forsyth
Yes.
way of getting around all this.
That's
but
right.
Mr. Naffler says, well, that doesn't work when it's the same actor.
Yeah.
And it's clearly a distinction from Percy and Hall, as indeed
It is.
Justice Sheeman recognised. Whether it goes far enough is, of course, what we're arguing about.
Well, we say, sorry, having gone through the possible identities of the original, or the maker of the flawed decision, there is also one other important thing to bear in mind about arbitrariness, which is that the functions of secretaries of state do change from time to time, and functions do get devolved to other departments and other secretaries of state. And
I mean, all secretaries of state are constituted the same office, I thought. There's a sort of, isn't that right? I can't believe the answer to this is going to depend on which Secretary of State.
And that's precisely
the government promoted this order.
And if I may respectfully adopt that is exactly our point. That the answer cannot depend on that because it is potentially so arbitrary to make that happen. The only way that you could really do that is to invent the new tort of an unlawful administrative action. But I don't just say that out of theory, because the next case I'm going to come to is an interesting case because it cites the second actor theory and looks at it in a little detail, and yet upholds the lawfulness of the second decision, despite the fact it was made by the person who made the unlawful first decision. So it was actually a first actor case, and having looked at the second actor theory, the second decision was actually upheld. This is the case of Mulvenna. It's Authorities 4, tab 49, and it's MS 1677. The best place to start, I think, is MS 1679. It's the third page of the...
I wonder whether that reference is right. 1677, tab
Yes.
49.
Is the title page of the journal in which the report
right.
appears.
I'm sorry.
And then if you turn over, you'll see the beginning of the
Very
report
well.
at the very bottom of the page.
Sure.
And then at the top of the next page, the head note really explains the factual background. The claimants had applied to the Secretary of State for Communities and Local Government for a change of use of sites to allow caravans to be used as residential accommodation. The planning inspector tasked with reporting to the Secretary of State had recommended that temporary planning permission be granted. In both cases, the Secretary of State had determined to recover jurisdiction and then gone on to refuse the planning permission sought. I'll come back in a moment to explain that. I should just draw attention to the fact that in the next paragraph it's recorded that in a subsequent decision, more in quotes, the High Court held that the Secretary of State's policy of recovering these appeals was unlawful. Then the government allowed planning inspectors to decide the appeals after all. The claimants issued judicial review proceedings challenging both recovery decisions and the failure of the Secretary of State to revoke the decision on their appeal. Now, recovery, as I know some members of the court will know, it's a process by which, if an inspector is supposed to, on the ordinary course of events, decide the planning appeal, the Secretary of State can issue a recovery decision that has the effect that the Secretary of State will decide the appeal rather than the inspector. And the question was, well, if the recovery decision is unlawful, it's a nullity, what about the decision on the planning application itself made by the Secretary of State? That's a second decision, and the Secretary of State would only have made that after recovering the appeal to himself. It's a long judgment, and for present purposes, can I draw attention to page MS 1693. It's page 502 of the report. It's a section that starts looking at the law.
Sorry, the MS number again?
1693.
Thank you.
At paragraph 64, Mr. Justice Cranston starts by referring to the law's absolutist position that an unlawful decision, whether within jurisdiction or not, is void, not voidable, and then cites a number of familiar authorities. He goes on to Boddington at 65, and one of the paragraphs that he quotes from Boddington is at the bottom of that page, which is Lord Steyne's own reference to the second actor theory, and Dr. Forsyth, as he then was, Professor Forsyth now, his article setting out that theory. Going over the page to MS 1694, at paragraph 68, he sums up the authorities. He says, law appears to be this: unlawful administrative acts are a nullity, but they are presumed to be valid until the court rules otherwise. Once the court declares them to be unlawful, it is confirming that they have been unlawful from the outset, in other words, that they are void, not voidable. There is a practical problem, however, that parties may have taken subsequent action, assuming these unlawful acts to be valid. If they are a nullity, subsequent acts taken on the strength of them are also a nullity. The result might be administrative chaos or even political crisis if a myriad of subsequent acts are void. To avoid the domino effect that all subsequent acts are also a nullity, various solutions have been posited. One is that in some cases judicial ruling should be given prospective force only. That approach did not attract the support of the House of Lords in ex parte Evans. Second is favoured by Professor Craig is the discretion. Yet there is high authority that, generally speaking, parties succeeding in a judicial review will be entitled to relief. Thirdly, there's Professor Forsyth's conceptual approach, the theory of the second actor. So he's there specifically looking at that. And then at 71, he says, in practice, it seems to me that the courts will adopt a combination of techniques, as Professor Elliott suggests. The courts will be guided by the language of the statutory scheme, its history and policy, but in the exercise of their discretion will also take account of the consequences which would ensue if they concluded that a power could only be exercised on the basis of a valid first act. Discretion may enter the picture. Now, the result of this case was that the second decision, the decision on the appeal itself, was held to be valid, notwithstanding that the recovery decision was ultra vires and a nullity. And that was done by referring to the statutory scheme in which the Secretary of State was the person vested with the jurisdiction to decide the appeals at all times, and the planning inspector, if the inspector had decided the appeal, was only exercising the Secretary of State's jurisdiction on the Secretary of State's behalf. So there's a reference to the very specific terms of the statutory scheme in making that decision. And it is notable, and one of the reasons why I draw attention to this is because despite having looked at the second actor theory, this is actually entirely a first actor case. The Secretary of State made the recovery decision, then made the appeal decision, and the second decision was nevertheless lawful.
Does this come back to the same point, which I think you've made yourself, namely that one must adopt a solution which is considered to be fair and pragmatic and appropriate in the circumstances of the particular case.
Absolutely.
And here we're dealing with the question of the liberty of the subject, which is obviously a fundamental right.
Yes, it is. But we also point to the fact that it is being interfered with in the public interest. And the decision as to whether or not you let somebody go with the risk that they're going to abscond and evade immigration control or commit further offences, or you keep them in detention to protect the public, that's a decision that the Secretary of State has to make at that time. And the only reasonable way of approaching that question, we say, is precisely the same approach as in Percy. You've got to look at how things appear to be at that time.
Just looking at the case we've just been looking at about planning, could it actually be explained by saying that the error in recovering the decision to the Secretary of State wasn't material to the result?
It's difficult. I think it's difficult to analyse it like that, because it is clear that but for the unlawful recovery decision, the Secretary of State would never personally have decided the appeal. So the unlawful recovery decision had to be material in at least that sense.
Sorry, it wasn't the inspector going to decide it the other way.
Yes, the inspector would have decided it the other way.
So it's clearly material.
Yes,
The Secretary of State decided to come in.
Yes.
And yet,
So in the result too.
Yes, I appreciated that. It's a different question.
Yes. It was clearly material. Both in the result, but also in the history, because the Secretary of State's decision would never have happened without the recovery decision. Can I say just for the court's note that Connor's this was upheld by the Court of Appeal in a case known as Connor's. It's Authorities 4 tab 52 at MS 1774, but I don't need to turn that up now. And the third example is a case that I've already referred to, which is TN Vietnam. Just so you have the reference again, it's Authorities 5 tab 55 at MS 1844. Can I just, again, just give you a reference? At paragraph 77, which is on MS 1859, Lord Justice Singh refers to the fact that in that case, the decision that was involved, that is to say the second decision, was the decision of a judicial body. And there is a link from what he says there to the principle that there must be finality in litigation. One of the arguments that is raised against me is that the law recognises that even where there are sequential decisions, that the last in those decisions can fall because of errors in the first. We say that once you look at the case law in the way that I invite the court to, that is in one sense true, but it actually helps not at all. The reason for that is because sometimes it makes a difference and sometimes it doesn't. And what you have to do is to look at the context in every case.
Well, it looks as if Lord Justice Singh here is expressing concern about the domino effect of subsequent decisions being invalid if the first was based on a nullity of some kind.
Yes, and that's exactly the concern expressed by Mr. Justice Cranston in Malvena. Yeah. Yes, it's an obviously something that concerns the court. Can I say that there are two cases I'll just refer to quickly on this. One is that this flexibility that I'm urging that the court to take is reflected in lumber. I might go to lumber a little later, but can I just mention that one of the underlying features in lumber is that this court expressly said not every public law error in the decision to detain, will undermine it. There must be some sort of filter, and that is an example of this, or rather, perhaps I should put it like this, of the court not resorting to dogma in deciding this. And the other case, as it's been mentioned in Mulvenna, is Boddington, because thinking again about the identity of the maker of the first decision, in Boddington, the bylaws, if I remember correctly, were made by the railway company, but the prosecution was being brought by the police. So two separate bodies. And if the identity of the maker of the bylaws mattered, then you'd say, well, it's a second actor thing and you can rely on it. But actually the result in Boddington was that no, the defendant could attack the bylaws because that was the right thing to do in that situation. So again, you see the flexibility. There's nothing doctrinaire in any of this. There's academic commentary on this. Professor Forsyth's article is well known. I don't actually think we've got it in the bundle, but I think it's been cited often enough. The one thing that we did find was a relatively recent article by Professor Feldman that I've mentioned. And you do now have this in tab 5 of the supplementary bundle. Now, I should say at the outset, you'll see from the first sheet that this is published in the Cambridge Law Journal, and it's from 2014. The two cases listed as cited are Anisminic, obviously, and also Draga, which is how this came to our attention. I should say that in the way that academics are free to, he proposes a number of things which I can't because of the doctrine of precedent that we have in these courts. I have to work within the scheme of what the courts have decided. But if you look at the abstract at the bottom of the first page, section 1 shows that the idea founded on the principle of legality that all legal flaws make a decision void as a matter of law is erroneous. Infringing a legal requirement may not affect validity or may make a decision only voidable. I still recall the stinging criticism of our submission in Lumber as a throwback to pre-Anisminic days, but if as high an authority as Professor Feldman is prepared to propose this as a way forward, perhaps it wasn't quite as outrageous as it seems. On the top of the next page, you'll see that he describes 3 propositions as flawed, and those are that all errors in the course of making a decision or rule are to be regarded as errors of law. All errors of law make the decisions to which they relate null and void. If a decision is a nullity, it can have no legal effect. We have been increasingly paying lip service to these propositions, he says. Now, I don't go as far as this, and I can't.
And we were just thinking about the case we decided a couple of weeks ago, which we...
Well, we said that if a decision is a nullity, it can have no legal effect. Well, Professor Feldman, who's, of course, a very eminent
he is
commentator,
and so
is noted for his enterprise.
No, I think we can distinguish the case of 2 weeks ago as being rather special circumstances.
Fortunately, I'm not in the position of having to propose this as authority for these
No, but it's very useful
positions
to
or
have
advancing
this.
these arguments. But to be serious, the value of this article is twofold. First is that there's a section starting on page 7 saying what courts actually do. And it goes through a large number of decisions, including, you'll see at page 9, a reference to, at some length, to Draga. And then
It doesn't seem to be paginated.
it's the bottom right-hand corner of each page, and quite faintly.
Oh, yes, I see it. Yes, thank you.
So Draga is dealt with there and on the subsequent page. I'm not going to read this out now, but I invite the court to look at that. Amongst the other cases referred to, if you go to page 18 or 19, you'll see, again, quite a lot of time, 19 onwards, devoted to Lumba and Kambadzi. And again, he discusses the difficulties thrown up by those cases. Also, if you go to 27, 26 and 27, there's reference to Hoffman La Roche on 26, Percy and Hall on 27. Then, starting at page 29, he reaches some conclusions about this. Part of it is his theory, but for our purposes, can I invite attention to page 30, where he says, we've identified 7 principles which operate alongside the principle of legality and can mitigate its potential to operate in antisocial ways in some circumstances. And importantly, the principles 3 and 4 are the principle of certainty, that's legal certainty, and the principle of finality as a particular aspect of principle 3, that is, say, judicial finality or finality of judicial decisions. And then also, importantly, principle 7, courts try not to make decisions or give remedies which would cause administrative chaos or be morally questionable, which, when you're talking about powers to be exercised in the general public interest to protect the public, has some relevance. The whole of that section on court decisions shows that there's this flexibility and the non-doctrinaire approach actually being applied. And that is really all that we invite this court to do in upholding Draga.
His principle 4 looks very much like the principle of estoppel.
Well, yes, it does, and that's why I did mention this a little earlier, that it clearly comes from the same place.
Does he identify any authorities for that?
He is referring to, I know he refers to Draga as one of the cases that illustrates that.
Well, never mind, we can read it for ourselves.
So that this is going back to page 9. So he deals at the top there with third and fourth principles, certainty and finality. But it is in the language of finality of litigation. And that's why I don't think he uses the term estoppel here. But as I say, it may be a distinction with relatively little difference, given that it comes from the same origin.
I did. I mean, no one's referred to the judgment in Privacy International. I'm not suggesting they should, but I did there refer to the sort of limitations of the anismic principle in certain contexts, including Lord Walker's qualification in Lumba and so on. And I actually cited another very interesting article of Professor Feldman.
I think if one were to do the sort of academic analytical exercise, one could probably collate quite a list of cases in which judges have expressed some discomfort with the doctrine, because it does lead to unfortunate results. On finality of litigation, while I have this in my mind and while this bundle is open, can I just draw attention to the relevant parts of CADA? So this is now tab 6 in this bundle. And if you can, if I just show you where the relevant parts are, it's page 2626, paragraph 56 in Lord Hope's judgment. This is where the section starts. At 59, he said he would have liked to give a prospective only judgment, but he didn't think he could do that. And then at 60, he says that the principle of legal certainty applies, and what he pointed out was that where there were cases that were still underway, the law as now explained would have to apply to that, even though they obviously dealt with past events. However, once a case had been definitively concluded, then it was too late to regard that as automatically affected by this decision. It was done, and the result in the litigation was final. In Lord Rogers' judgment, page 2639, paragraph 98 onwards, he agrees with that. So I hope that will help to locate the relevant parts in that judgment. Before going on to the specifics of the case, can I just mention one more case, which is Evans? I don't need to turn it up because we all know Rock Hill Prison ex parte Evans number 2. It's always cited against me in cases like this, but the reality is that it's often misunderstood because it wasn't ever a two-decision case. It was always about a different issue. The detention under the sentence of imprisonment was authorised and only authorised by a court warrant. And the court warrant said, this is the duration of the imprisonment. But the problem is that the intervention of statute meant that the warrant did not mean what it said. And when you tried to work out what it meant, you had to understand the amendments that were made to it by the statute. And it is part of our law that the statute can only ever have one meaning. And that was the problem for the prison governor in that case, which is that he had a piece of paper. He had entirely reasonably thought that it was interpreted in one way because a court had said this is the meaning of the statute. But when a later court decision said, no, that was wrong, and the statute always had a different meaning, then this piece of paper was then understood to have meant something different. And so, however reasonable the error that was made by the governor in interpreting the warrant, he was always either right or wrong, and eventually it was decided that that interpretation was wrong. It never was a two-decision case. It's good authority for the retrospective effect of court judgments, but that's one of the things that is not in issue in our case. So Evans doesn't actually illuminate this problem at all. Can I then, in the final part of my submissions, deal with the things which are set out in some detail in our printed case, which is why I'm able to go through this quite quickly. The argument on DN's behalf is really focused on the phrase bore on and is relevant to the detention taken from Lumba. And can I say, I of course accept that as a matter of history, one can see how that can be said to have been. In that historical and factual sense, of course, there is relevance, and it's the same sort of situation as in Malvena. But that doesn't do anything to answer the question before the court, because the real issue is whether the error that took place was, in non-technical terms, just too remote from the decision to detain to be regarded as bearing on and being relevant to the decision to detain. We have drawn attention, and in some detail, to the parts of the judgments in Lumba that show the focus on the decision to detain. I accept that, in a sense, that was, of course, what Lumba was all about, and so it's unsurprising to see that. But we say that if you read the tests carefully, and we've given all the references in our case, you will see that they do focus on the decision to detain, what was wrong with it. And there are, despite the different ways in which the tests were expressed, that is what they revolve around. And that's of course exactly what one would expect, because the question always was, is there something wrong with the decision to detain that undermines its validity for the purposes of justifying detention? I should stress it's no part of our argument to ask this court to decide which of these tests was correct, whether the subsequent general acceptance of Lord Dyson's formulation is actually right or wrong. That's all perhaps for another day. But it's the language that's being used that is important. We do draw attention, though, to the fact that all of the tests ameliorate the strict doctrinaire position. That is all of a piece with the general propositions that I've been drawing attention to. And the other important point is that at least two of the tests are positively inconsistent with any notion of looking at an earlier decision. And those are, I'll give you the references, my Lord Kerr at paragraphs 250 to 251, that's MS 908, and Lord Walker at 193, MS 893.
I had thought that you had conceded that there were circumstances in which an earlier decision would invalidate a subsequent detention. But are you limiting it to the precise Lumba and Kambadzi situations, error within the actual detention decision?
Yes, I do limit that. Limit the concession to that.
I see.
Because the reason I describe it like that is because there has been an analysis put forward of Lumba that there were three sequential legal errors. One was in formulating a policy which was unlawful because it was blanket. The second was that it wasn't published when it should have been. And the third one was in then applying that policy to detention. I think on a different occasion, if it ever becomes necessary, one might have to argue about whether any of those was the operative legal error. But for present purposes, I think I would have to accept that they were all of a piece because they all went directly to the detention.
Well, we know that the facts of those cases did.
Yes.
But, I mean, have you forgotten, for example, what Lord Justice Sullivan said in paragraph 72 of Draga at 1009? If you've got that to hand. Bundle 2.
Yes.
23, 1009. While it may be difficult to distinguish between those public law errors which will render a decision to detain unlawful, those which will not, I have no doubt that reliance upon a device to maintain a deportation order, without which continued detention could not lawfully be authorized, is a public law error in the decision-making process which renders the continued detention unlawful. So even within the decision which you are commending to us, there is an acceptance that certain earlier decisions will invalidate.
Yes, I see that. If something goes so far as to be a device, so that the deportation action is undermined on that basis, then I can see why the detention may be regarded as unlawful. I don't think it's necessary for these purposes to decide whether that is because of a domino effect or whether, because there's a perfectly good analysis of what happened in this situation, whether the decision to detain following a device is itself flawed, because the decision maker must have known that there was simply a device being used to perpetuate the deportation action. Or in other words, one might say that the decision maker knew, the detention decision maker knew that the deportation wasn't going to take place at all. And that could be within the four corners of the detention decision. rather than through a domino effect. That wasn't analysed there. It's not our situation. So we haven't analysed the analogies there, because what we have is clearly a case which will only work on a domino basis.
Very well.
Can I just give the court some references to Kambadzi, which, sorry, is returning to the theme of directly to do with the decisions to detain. Kambadzi, Authorities 2, tab 22, MS 946. The word directly was used at least 3 times in these judgments, suggesting that the court was thinking of something that was close to the detention decision. Lord Hope, paragraph 41, MS 964. Lady Hale, paragraph 77, MS 975. And Lord Kerr, paragraph 88 at MS 978. And while on this subject, as Lee Hirons is now before the court, can I also direct attention to paragraphs 21 and 21 and 39 of that. In particular, it's 39 that refers to the need, as Lord Wilson thought, for a direct link between the legal error and the lawfulness of the detention, and the detention. So these authorities are all of a piece on this. And so what the claimant is trying to do, undoubtedly, is to extend what you see in these detention decisions to the domino situation that we have. There are 4 routes which we have advanced in our printed case. Can I just mention what they are? Statutory construction, that is, I think, the last thing I will spend some time on. There is the fact that there are 2 distinct legal structures for deportation and detention, including different avenues of challenge. That is a theme which was much discussed in Draga, and for those 2 reasons I don't need to say anything more about that, other than to remind the court respectfully that the challenges to deportation can of course go on even after detention has come to an end, as in DN's own case.
So how do the different avenues, which certainly exist, help us decide this problem?
They do, because what happens is that you get final judicial decisions in the deportation avenue, and the whole point of Draga is that certainly when that has happened, the detention decisions must be regarded in that light, because the deportation action has been conclusively upheld by the courts. So they're parallel streams. And the fact that they're parallel streams shows that the domino, using that constructed domino effect, is a stretch. The third was to consider analytically what would be the consequences if an unlawful detention challenge was brought on its own, without there having been any previous challenge to the deportation. We point out that it basically means that an individual could bring an unlawful detention claim, and so long after the deportation action had been done and dusted, without challenge by him, reopen all of the aspects of this and look at the basis of the deportation, the basis for all the decisions that were taken. And in a paragraph 2.1 case, we draw attention to the fact that that would include reopening the criminal conviction and sentence of the criminal court in a court-recommended case.
Have recommendations for deportation gone out now? Mr. Tam, I seem to recall Lord Hughes telling the court, in a case in which I was, that they've gone now.
I don't think
that may not affect the point you're making. But
it doesn't affect the point I'm making because they haven't technically gone. They're not used as a matter of practice. They're, I think,
Right.
very seldom used. But the root is still there, and the statutory provisions are still there, and
Very
I'm
well.
entitled to rely on that as part of the argument. There are also the difficulties which the court will be aware of how you identify a public law error, because some are actually pretty close to the edge. And in fact, I think the High Court spends a lot of its time complaining about complaints about errors of fact being dressed up as errors of law. And that would be something that would happen all the time. The fourth one is one I did deal with orally a few minutes ago, which was the fact that this cannot depend on the identity of the person making the error and whether it's the same person as the person doing the detention. I'm not going to go back over that. But in the last few minutes, I will just ask to draw attention to the problems with D and the Home Office. We rely on ULA. We cited ULA. We were not in the least bit ashamed at citing that because that is exactly what we say the statutory construction approach would be. But I need to show you just quickly that there were problems with ULA. Sorry, there were problems with D in the Home Office, which was the case which criticised ULA. This is Authorities 1, tab 16 at MS 661. The claim was made by a family of asylum seekers who were detained at Yarl's Wood. If you look at paragraph 4, which is MS 666, you'll see what the general nature of the claims was. That they were, the detention was unlawful because it breached Article 14 and breached the Race Relations Act, and there was a claim for damages for negligence. Those were unaffected by the D decision. But what the court was considering was the viability of their claims for damages for false imprisonment and claims under the convention. And all of the claims for false imprisonment were based on things which we now understand to be classic lumber claims. So if you go to paragraph 34, MS 672, you'll see all the breaches of policy that were being alleged. So 35, little 1, detention should be a last resort. Detention must be strictly necessary at little 2. Little 3, strong grounds for believing that the individuals were absconding risks, and so on. So now we understand from Lumber that these were all challenges directly to the decision to detain and comprehensible, easily comprehensible on that basis. The reason why D in the Home Office's criticism of ULA is, we respectfully say, misplaced. Is because of the way in which the argument was put. If you look at paragraph 59, Lord Justice Brooke identifies the difficult questions to be determined as whether the law grants any form of immunity to an immigration officer. And that was a way in which the argument progressed. The problem for the criticism of ULA that you find in D is that ULA was never a case about immunity. When you come to look at it, you will see that it's just a straightforward statutory construction decision that as a matter of statutory construction, the detention powers arise only when, or that they arise when the factual condition is satisfied, as we submit. And that's all it is. And so the criticism here is, with respect, misplaced, but probably misplaced because of the way the case was being argued at the time. When Mr. Justice J in Komoka, that's Authorities 559 MS 1925, in effect adopts those criticisms of Ola made in D and the Home Office, he has, with respect, fallen into the same error. Certainly at that level, and without the detailed consideration that we have been able to advance to this court of the general line of authority and the statutory construction reasons for it, it can't be taken to be an authoritative criticism of the decision in Ulla. We say that as far as the statutory construction is concerned, it's as good as a decision as any, but our argument actually stands up for all the reasons we've set out in our printed case, even without that backing. If I just have 60 seconds to say something about precedent, we respectfully say this is not the case in which to embark on that. There's a big issue that's got to be decided here. The question of whether the Court of Appeal was right or wrong to regard itself as bound by Draga is really of academic interest. There may be other cases in which it will really matter to know whether a Court of Appeal is bound in this way. But this is not that case, and given the very light touch that the Learned Friends have applied to this issue, we invite the court not to embark on that. Lords, with apologies for having slightly overstepped the mark, those are our submissions, unless I can assist any further.
Thank you very much, Dean. Ms. Anderson? Yeah. Now, Mr. Naffler.
My lords and my lady, I have four initial points to make, which I hope I can make quite speedily, if that's convenient. Firstly, the tribunal decision and what the tribunal decided, the AIT in this case. My Lord Wilson drew attention to para 19 yesterday. I also draw attention to para 31 at memory stick 316, which makes it crystal clear what the tribunal thought they were about. And also memory stick 318, that's the refusal of permission to appeal from the AIT. The second short point is, in response to my learned friend's carefully chosen language, that it would have been, quote, wrong, unquote, for the respondent to continue to try to remove Mr. N in the light of the EN Serbia decision. In my submission, it wasn't a question of just being wrong, but of being unlawful. If the Home Office had thought that Mr. N had in truth committed a particularly serious crime, of course they would have continued to try to remove him. And you see that, and I flagged this up in opening, but I do so again, memory stick 334, after EN Serbia, the respondent continued to try to remove Mr. N, this time on the basis that he was allegedly vulnerable to having his refugee status ceased because of changes in Rwanda. They continued to try to remove him and then gave up on that basis as well, restoring his ILR. And they simply wouldn't have done that if they had believed there was any realistic prospect of showing he had committed a particularly serious crime. The third short point, without wanting to do Section 72 to death, we do continue to submit that it is a self-contained code, and we rely on Section 72.1, which says that that enactment applies to the purpose of the construction and application of Article 33.2. We've obviously already referred to 72.9 and 10. What was the purpose of 72? What was it trying to achieve? And obviously, one then construes the section in the light of the purpose. Two things in our submission. Firstly, it was taking away an area of complex and rather uncertain decision-making from decision-makers and the tribunal, i.e., what constitutes a particularly serious crime. Two, it was streamlining, and one might say truncating the appeals process through the 72, 9 and 10 mechanism. Now, my learned friend has referred to an extract from 2016 guidance, strike law guidance, cannot be used to construe legislation. And I point out that this guidance is 12 years too late, and you've only been shown one little part of it. We'll hand up the whole guidance later if we may, and you'll see it, pages 25 and the whole of 32, that although it's not clear, certainly putting what my learned friend has referred to in context, overall it does look as though the Secretary of State's view was that, for what that's worth, view was that Section 72 was intended to be comprehensive and exhaustive. So we'll hand that up. As to Section 33 of the other Act, we've only just seen that, but there's obviously one response is that it was no longer in force in 2007 when these events occurred. But second, addressing the point of principle, the answer must be that when a certificate was issued under the Act that's been referred to this morning, once the 2002 Act was in force, that certificate would have to be issued compliantly and in accordance with Section 72. So, and then the fourth short point I wanted to make at the outset was to address the chaos theory introduced by my learned friend towards the beginning of his submissions yesterday. And he drew attention to the fact, and it seems to be a fact, that there was a gap of 4 to 5 years between the coming into force of the 2004 order and the first cases coming through questioning the validity of that order. And I think that was all in aid of a general submission that this circumstance showed how difficult it would be for the Secretary of State if lately made claims of this kind could sort of disrupt earlier decision-making. And the point I make here is that we don't know, and there's no evidence. I mean, we genuinely don't know, and there is no evidence as to why there was that gap. And the respondent hasn't put in any evidence about it. We don't know when the respondent started implementing the 2004 order. There may have been a gap. We don't know whether the initial tranche of cases where the respondent implemented Section 72 and the 2004 order may have involved cases of people who had been convicted of crimes with sentences for over 2 years. For all we know, initial appeals may have succeeded, all of them, or just taken years to proceed through the system. There simply isn't evidence about that. But suppose, hypothetically, there was a cohort of appeals that failed in those earlier years where the order played a part. There's no reason to suppose and no evidence that the order played a material role. But in this case, it did, and you've seen the evidence of that. Moving on now to some of the more substantial issues, and one of them has raised its head again today as estoppel, an issue estoppel that my Lord Carnwath has raised. And he asked why no one has discussed this. In fact, I think I did yesterday when I was talking about legal certainty, and I made the point that the respondent hasn't submitted that Mr. N is precluded from arguing the points he wants to.
No, I mean, I noticed you did say
yes.
that. It was that in a way which I was thinking about last night. Why?
Yes.
So, you're now going to tell me why.
Well, for the same reason that the important point is that the respondent hasn't relied on res judicata, issue estoppel or abuse, and we are where we are. And the point that I sought to make yesterday was that the reason the respondent hadn't done so was probably the reason that my learned friend in fact gave this morning, which is that there is a lot of case law, and we have looked into it relatively recently. There is a lot of case law which suggests there is a very, very strong general rule, res judicata and issue estoppel, being private law concepts, will not be applied even by analogy in the judicial review context. Now,
Tell me one case which says that.
yeah, well, we can hand up a whole list.
No, I just
Have a
want,
whole
you know,
list.
if it's such a clear proposition, one would expect to find it. But there's
Yes.
there's a whole passage of Wade which discusses, under the heading "Res judicata," which discusses the application of that principle in public law cases. So I'm slightly surprised if you say it doesn't apply.
Well, that is what we say.
The way it's put is on finality, and it said already that's analogous, but I'm not sure where that gets us really.
There is, we'll
You know, the important point here on finality, and this is a point that is made against you, is that you had the opportunity to appeal the deportation decision. You did. Those proceedings went through, and they were final. And it said, well, that's a very good reason for treating that as definitive on that
yes. But let me come back, please, and just say a few more words about res judicata and issue estoppel. I mean, if invited to do so, we will hand up our list of cases and our material on that. If
well, I'd like to see. Well,
but
I'd certainly like to see something on it.
Yes.
I prefer to see your best case rather than a whole lot of cases which may or may not be of help.
we can do that. We don't have it right at our fingertips because the issue wasn't raised, as I was pointing out yesterday. But can I just raise and come back to my Lord on Thrazi-Vulu, which was the one case that my Lord referred to, the planning case, because I do have that here in front of me. And this is the one case where clearly issue estoppel was applied by analogy in this planning case. It's a planning enforcement case. And it wasn't a judicial review. It was a case that went through the planning system. Somebody won a planning enforcement appeal, and then the council came back later on and tried to enforce planning control through a second set of proceedings, and that went up to the House of Lords. And the person in that case, it wasn't a judicial review case, was allowed to rely on issue estoppel. And the critical passage, which I can read out, because it goes to the real heart of this whole issue and the real heart of this case, it's Lord Bridge. And what he said, and in this very exceptional case, is this: in relation to adjudication subject to a comprehensive self-contained statutory code, the presumption, in my opinion, must be that where the statute has created a specific jurisdiction for the determination of any issue which establishes the existence of a legal right, the principle of res judicata applies to give finality to that determination, unless an intention to exclude that principle can properly be inferred as a matter of construction of the relevant statutory provisions. In other words, in that very special context of planning control, obviously it wasn't a judicial review, wasn't a false imprisonment case, Lord Bridge expressed the view that effectively issue estoppel applied, and that it could apply in other cases, subject to statutory construction. And that's where one comes back to Kawaja and the fundamental principle of statutory construction, where false imprisonment is an issue, which absolutely...
Is not a case about damages for false. Kawaja is not a case about the tort of false imprisonment, is it?
No, but it's a case about
I mean,
how...
obviously everyone accepts that false imprisonment is a very important issue, but I mean, that doesn't mean you've got a private remedy for damages. That's a quite different issue.
No, what Kawaja is about is a case about the liberty of the subject and how statutory construction operates in that context. And the principles that come out of Kawaja, in my respectful submission, the crux of our case, although the Secretary of State hasn't actually responded on Kawaja, the principles that come out is that unless the legislation plainly and unequivocally makes the contrary clear and compels the contrary conclusion, legislation must be construed in a way that doesn't cut down the rights of individuals. So applying that to the Thrazi-Vulu approach, the real question is the deportation appeal machinery a statutory code which should be construed as being so clearly intended to give finality to the decision on deportation that it excludes the fundamental right of the person concerned to question the lawfulness of his detention later on in false imprisonment proceedings. And one of the things we did yesterday was draw attention to the fact that it is inherent in the deportation of statutory machinery that it isn't absolutely final and determinative, see MA Pakistan. And then we, of course, made all the other submissions that I made based on fundamental principle as to why this particular scheme could not possibly, in my respectful submission, be construed so as to preclude somebody raising the unlawfulness of their detention in a context. And so the one, and we say it's, if not the one, it's one of those very rare cases where one sees issue estoppel, not in a judicial review context, but in a public law context, in this either one-off or a very rare case, at the heart of the reasoning is that it is all ultimately subject to statutory construction. And that's why, in a forced imprisonment context, issue estoppel simply won't work in this case, in our respectful submission. So, then...
I mean, if there was an issue estoppel against your client, then the deportation order in his case would be valid. He'd better be deported.
Yes.
No, as you say, you can change it. It's a continuing discretion. All we're talking about is the original deportation decision, which was upheld in the AIT. And that was the foundation of the detention. Obviously, if events change, then the Secretary of State's got to reconsider the matter. So it's what he did here.
There's obviously much to be considered here. I mean, our position would be that the whole chain of events and all the distinct parts in that chain, the decision to deport, the detention decision, and the deportation order were all fundamentally flawed.
Yeah, no, I understand how you're
the whole
putting it.
Foundation was the order.
But we don't want to extend this because, but I'm certainly surprised at your suggestion that the Thrasivula is to be treated as exceptional. And I'm certainly not aware of anything in the textbooks which says...
I certainly accepted, as I accepted yesterday, that abuse of process comes into the picture more in public law proceedings. But my point is that res judicata issue estoppel abuse of process have not been made against us. One then gets to legal certainty, the most anodyne form of that overall principle. And then one looks at Brockhill. I mean, one has all of those judgments of the House of Lords in Brockhill balancing legal certainty expressly in the case of Lord Hope. Certainly all the others, they're balancing legal certainty against the liberty of the subject. And the balance comes down unequivocally against legal certainty. Unequivocally in that case.
Right,
and one can say the same, of course, about Boddington.
If you could let me have your notes or anything you'd like to add on that.
Of course, we'll send them to my learned friends. We have a yes, we. I mean, it's a useful note which sets out the key passages from the cases, but we can also append cases and circulate that. But I'm certainly not saying that abuse of process is never applied in public law. I'm not going that far. So yes, our written case, I went through at something of a gallop yesterday. On the question of why we say this is not one of those extremely rare cases where the court should consider making an exception to the ultra vires principle, the void nullity principle. And I just draw attention, just in case it gets lost, I'm sure it won't have done, it's paragraph 47 of our written case, which really sets out all our arguments on that, which I don't need to repeat. And I turn to the exceptions, though, that the respondent relies on, which we say are completely illusory. First, Percy and Hall. I made a raft of submissions about Percy and Hall yesterday and why it simply wasn't on all fours with this case, and I don't intend to repeat those, But just to perhaps address a couple of the points that arose today from the bench, is this a case on its own facts? Yes, very much so. If one looks in particular at Lord Justice Simon Brown's judgment, as he then was, you can see Lord Brown very characteristically, if I may say so, really seeking to find what in his view was a fair and just solution on very particular facts. And he probes those facts and he draws attention to the specific facts very, very carefully throughout to justify what he considered to be a fair and just solution in that particular case. And as I mentioned very, very briefly yesterday, and I just flag it up, Lord Hope in Brockhill at MS 588, and it's 34 capital C and 34 capital F.
Sorry, the MS number again, please.
588, and it's 34 capital C and 34 capital F to G. He appears to treat it as a case about as a case about wrongful arrest, I should say. And as I flagged up very briefly yesterday, but it may have got slightly lost because I was going quite quickly, it's volume 2, tab 30, Mr. Justice Lewis in his book, Judicial Remedies.
I'm sorry, 588, you say? Are you sure that's the right?
Yes, it should be.
Oh, yes, yes.
Yes, it should be.
Sorry.
And then, thank you. And then volume 2, tab 30, Mr. Justice Lewis in his book, Judicial Remedies, suggests that even as a case about wrongful arrest, Percy doesn't appear to be reconcilable with Lumber, and we rely on that. But
you're not asking us to overrule Percy expressly? Or maybe you are.
yes, I am. Yes, we do say it is wrongly decided because of Lumber. And one sees the criticisms of it in Mr. Justice Lewis's book. Certainly as a case that, certainly as a false imprisonment case, as a case about wrongful arrest, yes, one can see that the constables had a defence of reasonable and honest belief that an arrestable offence had been committed. So I don't repeat any...
You don't need to overrule it as such. You say it needs to be qualified.
Yes, sorry, that's right. So I don't repeat any of the other points I made about Percy yesterday. Can I move to TN Vietnam, which is volume 555? The critical point about this is that the statutory instrument that dealt with the detained fast-track process had been quashed simply because it gave rise to a real risk of unfairness in a significant number of cases. Not all cases, and one doesn't know how many cases a significant number would be. Therefore, the court refused to accept that the unlawfulness of that order would necessarily be material in every single appeal, bearing in mind that the tribunal obviously is under a duty to conduct the proceedings as fairly as it can. And I think one sees that at paras 84.
Page is that, please?
So, sorry, MS 1860. Well, really 80, 83 and 84, and then the 85 down to capital F. and I'm also asked to draw attention to paragraph 97, which says pretty much the same thing. And I just remind the court respectfully that I've accepted throughout, consistently with the agreed approach in Lausicus endorsed by Mr. Fordham QC, that we have to show that the 2004 order was a public law wrong that had a material effect on the decision to support Mr. N. The problem for the appellants in TN was that they couldn't show that the DFT, the quashed order there, would have had a material effect, or did have a material effect, on the fairness of their hearings. That's because sometimes it would, sometimes it wouldn't. Mulvenna, my learned friend has taken you to Mulvenna in the High Court at volume 449. Mulvenna was actually appealed, and the Court of Appeal decision is under the heading Connors in volume 4, tab 52. And the appeal decision is summarises succinctly and very usefully why it is that Mr. Justice Cranston, I think it was right. And if one turns to memory stick 1801 and looks at paragraphs 101 to 102, one sees the...
For whose judgment is this?
reason. This is Lord Justice Lindblom. And his essential reasoning is that the problem was that the appellants failed to seek a judicial review of the Secretary of State's recovery decision. Now, if they'd done that quickly, they could have quashed it, and then the Secretary of State would have had to reconsider his recovery decision. But because they didn't do that, he then went on to make a decision, make a planning decision. And what the Court of Appeal held here is that there was an express statutory bar which meant that the appellants could only challenge the planning decision properly through the planning appeals process. And because of that, the statute absolutely prohibited them from questioning the lawfulness of the recovery decision. So that's why the appellants lost in Mulvenna.
That arises from the specific provision of the Planning Acts, which
yes.
can't challenge decision by other means.
Exactly. And then Uller, just to remind the court, it's not just the criticism in D, it's the criticism in Lausicus and Kamoka, which we rely on in full in Uller, and I particularly draw attention to the reference in Kamoka to B, Algeria. This is the case in this court where Lord Lloyd Jones, on behalf of the court, and the passages set out in Kamoka, made it crystal clear that when Schedule 3 refers to deportation decisions and detention decisions, it has to be implicit that these are lawful decisions.
Could you just give us the paragraph to that, please, in Kamoka?
It's, if one looks at it through the lens of Kamoka...
Well, I don't mind where you get it, wherever you get it from, whatever's convenient.
B Algeria is volume 4, tab 51, and the passage is at... it starts at memory stick 1763, para 29, and it ends at memory stick 1764 at the end of para 29. In fact, go on to para 31, which ends at the bottom of 1764, and that's one of the passages referred to in Kamoka. So next, if I may, I wanted to say a few words in reply on the void from the start issue. and the academic articles that my Lord Carnworth asked to be referred to. So they're in the bundle already. There is an article by Professor Kane, I think it is at Volume 2, Tab 28, where he has a particular take on Evans Broghill. At Volume 2, 29, there's an extract from Wade and Forsyth, which probably bears particular attention, and in which Professor Forsyth reprises his second actor theory, which I think we would say is the one principled exception to the nullity doctrine. And even there, C. Shoesmith, the courts look at it with very great care. I say the one principled exception because it's the one exception that's based on conceptual reasoning rather than the idea that one can apply discretion.
It's not been specifically adopted by the courts, has it?
No,
it's
not
referred
as far as
to
I know.
on a number of occasions, but not necessarily.
It's floated as, and one sees this in Shoesmith and also in Boddington as something that the courts take seriously and will look at really carefully in an appropriate case. As far as I know, that's not actually happened, but it's the one satisfactory conceptual explanation of a way forward that actually does make sense, although one would have to apply it with great care. And whether it would ever be applied in a false imprisonment context, we say absolutely not, because the only important issue there is whether or not there is a public law error that bears on and is relevant to the decision to detain. But that's possibly a matter for another day. There is Mr. Justice Lewis, Volume 2, Tab 30, where he takes quite a strong line on nullity, and as I've already indicated, he explains why, in his view, Percy and Hall was wrongly decided in the light of Lumber. There's Professor Craig, which my Lord Carnworth drew attention to yesterday, Volume 5, Tab 66, and we've included today, first of all, an extract from Professor Mark Elliott's book, which I suggest, again, merits particular attention. And he sort of takes up the Forsyth baton, as it were, and has a further...
Is that the one...
That's in our bundle, yes.
One put in this morning?
This is tab 9, I think, where there are 3 authorities. We've also included De Smith, which my Lord Carnworth particularly mentioned for obvious reasons, and also an extract from Auburn and Moffat. Very briefly, may I just say a few words about Professor Feldman's article that we were shown this morning. And this is, I think, would it be tab 6 of the new bundle? Is that right?
Yeah.
So page 2, tab 5, I'm sorry, page 2, Professor Feldman says, over the last half century, English administrative law and theory have increasingly paid lip service to these 3 propositions. And in my respectful submission, that's not right. It's Hornbook law for public lawyers, but not all errors of law make a decision void. The error has to be material, the granting of relief mustn't be futile or completely disproportionate, various process requirements have to be made. And I draw attention to Lord Bingham's well-known article, Should Public Law Remedies Be Discretionary? That's at volume 5, tab 62, MS 2051. And that's the answer to Professor Feldman's erroneous starting point. Then at the top of page...
Sorry, why is it the answer?
Well, because it shows that public law lawyers and judges have always adopted a careful but flexible approach to deciding whether particular public law remedies should be granted or not. And Lord Bingham sets out the parameters of that discretion in that article.
Yeah, I see.
Yes, that's all.
Yes, no, I see that.
And then, rather uncharitably, at the top of page 4, the article says, despite saying that all errors of law make decisions invalid, which in my respect, Commission of Courts have never said, courts, he says, usually manage to get sensible results. And as far as we're aware, the judges always manage to get sensible results, sometimes with the help of appellate courts.
It's a very generous view.
Even when they're deciding against you.
Yes, even when they decide against me. Because these public law principles are more flexible and more powerful than Professor Feldman gives them credit for, as Lord Bingham's article makes clear. And as far as we've seen through this very lengthy article, Professor Feldman doesn't in fact proffer a single example of a case where he says a court has not managed to get what he calls a sensible result. And he sets out his principles, which I know Mr. Tam has referred to, and I make this general criticism of those principles and of many of the other academic texts, is that they, unlike Professor Forsyth and Professor Elliott, they do simply venture into a series of examples where, according to that particular academic, it would make sense to adopt a discretionary approach going one way or the other. And what these articles don't properly consider are the reasons advanced in Brockhill and Boddington, cases of the highest authority here, as to why it's constitutionally important that court decisions are almost always retrospective, and why public law decisions declared void are almost always void from the start, that these are fundamental aspects of our constitution which protect the rights of subjects, and that simply gets almost no consideration in this article. But where we do agree with Professor Feldman is at a point which my learned friend rather glossed over, and it's at page 28, and it's the top of page 28, where even Professor Feldman, with his highly discretionary approach, recognises that a line has to be drawn somewhere, and this is where he draws the line.
Sorry, what are you referring to?
This is the top of page 28.
Yes.
It says the position is different, however, and it's that paragraph. When a court holds that interfering with a person's right is unlawful, and he's not even talking about a right to liberty here, he's simply talking about a right and the need to quash statutory instruments retrospectively. He's referring to Ahmed here, a case where an ordering counsel taking away the right of a suspected terrorist to have recourse to their funds was held to be unlawful. That was treated as having to be void with retrospective effect. But this meshes with the passage in Boddington, where Lord Diplock in Hoffman-La-Roche was approved, where he said it's essential that unlawful statutory instruments are quashed from the start. And one theoretical underpinning for that, in addition to the need to protect subjects, particularly the liberty of the subject, is that quashing them from the start is simply giving primacy to what Parliament said the law should be. So one thing I'd like to come back on, I flagged it up in opening, though not to the extent that I'd like to have done because of the time constraints, but this is the concern that Lord Walker expressed in Lumber about the interaction between public law and private law. And he was worried about that, and my learned friends have raised that worry again, that can it really be fair on public authorities to have to defend private law proceedings, such as the tort of false imprisonment, when there are public law errors raised against them, when they don't have all the protections that would apply in judicial review. And I think the biggest worry possibly is the 6-year limitation period. And my learned friends go so far as to say in their written case that a false imprisonment action circumvents, that's the word they use, the judicial review time limits. And we say that's not right. The concern, just as a preliminary point, the concerns raised by Lord Walker were addressed by Lord Dyson in Lumber. And he explains why those concerns, and this is between 67 and 71, are catered for in his idea of what the ratio should be. And I don't go over those. But since those concerns obviously continued to trouble Lord Walker, we wondered if there was something extra we could add that might help the court think about those concerns. And the first is that, again, it's another fundamental principle, and it is this, that public authorities are held to the same standard that applies to private individuals. And we refer to the additional authorities, I think it's tab 2, M in the Home Office. It's a short but resonant passage at page 407. And it's between capital E and capital H. In support of their retrospective submission, Mr. Richards, Mr. Kentridge relied on principles which have been repeatedly reiterated down the centuries since medieval times. Mr. Richards, the king can do no wrong, king can't be sued in his own court. Mr. Kentridge, the historic principle linked to the name of Professor Dicey. And it's that Dicey principle that I rely on. So
what was the reference to that? I'm so sorry, Mr. Nafler.
This is 407, capital E to capital H in tab 2 of the additional authorities. I'm so sorry. The additional authorities.
Right. Forgive me.
Forgive me for not making it clear.
Thank you. Yes.
Yeah, so it's, if my lord has that,
Yes.
E to G, and it's particularly the views of Professor Dicey there.
Good.
Every man, whatever be his rank or condition, is subject to the ordinary law of the realm. Every official, from Prime Minister down to a constable, is under the same responsibility as any other citizen. So, I mean, this is obviously a broad principle, but I do say that any claim by the state that when defending false imprisonment proceedings, that the state should have safeguards and protections that aren't available to private persons needs to be considered in this context. And so I turn to the limitation period, first of all. As we all know, in judicial review, it's promptly, in any event within 3 months, extendable. Under the Human Rights Act, it's 1 year extendable. In false imprisonment, it's 6 years non-extendable. Now, what I say about that is this. Firstly, Parliament has legislated so that 6 years is the time limit for false imprisonment claims, whether or not the defendant is a private individual or the state. This legislation has remained in force despite the dicta of Lord Diplock as long ago as 1984 that Wednesbury principles can be applied in a false imprisonment case. The legislation has remained in force despite lumber. So we are entitled to submit that the fundamental principle laid down by Parliament is that public authorities should be subject to the same limitation period as ordinary people in false imprisonment cases, even though they may be required, are likely to be required to justify the lawfulness of their actions by reference to public law standards, which is obviously something that a private individual doesn't have to do. And that's the main point, because that's the main worry of the defendant. As far as concerns the subsidiary concerns, the first is that it's said that a minor public law error may lead to no relief being granted. And obviously it's true that where an error is immaterial in a public law case, relief won't be granted. But false imprisonment has got similar protections. Firstly, in Lumber, Lord Dyson said, it's not every breach of public law that's sufficient to give rise to a cause of action, etc., etc. And Mr. Justice Jay in Kamoka, and I just flagged this up, this is MS 1938, para 50, said that enables the false imprisonment court to dispense with claims where the error is immaterial. Secondly, I refer again to Lausicus and the need for an error in an earlier decision that's relied on in false imprisonment proceedings to be material. And thirdly, of course, I draw attention to the Lumber proviso that you're only going to get substantial damages if the public law error was a material cause of your false imprisonment. Next, it said that judicial reviews are discretionary. Judicial review remedies are discretionary, false imprisonment not. But I just point out again, with reference to Lord Bingham's article, that the discretion is highly limited, and the respondent hasn't been able to produce a single example of a judicial review remedy, or a habeas corpus remedy, of course, being refused where liberty of the subject is sort of an issue, and we're not aware of any. And the problem with Lord Walker's concerns, I mean, obviously they are concerns that must be taken seriously, and I've tried to address them conceptually in the way that I've done. But the fundamental problem with those concerns, as reiterated by my learned friends, is that no one has been able to come up with one single case, concrete case, in which recourse to the false imprisonment jurisdiction has actually led to an unjust result because of the absence of judicial review protective factors. There isn't a single concrete example of that, not since Lumber, not since, as far as we're aware, the year dot. And my final thought about this is that I think all of the justices in Lumber and Kambatsi, to a greater or lesser extent, have made it clear, explicitly or implicitly, that judges do have a certain reserve and flexibility in these cases, which leads me confidently to submit that if a case did come along in the false imprisonment context where a claimant was perceived as taking the system for a ride, the courts would have plenty of tools to deal with that appropriately. And so I come back just in the last few minutes to, well, I suppose to two things. Firstly, my Lord Wilson asked the question, what's wrong? What would be wrong with granting a remedy in false imprisonment in this case? The first answer was it would be unfair to the taxpayer. And that's, in my respect for submission, completely contradictory of every false imprisonment case that there ever has been involving the state, which repeatedly make it clear that it's a matter of fundamental importance that when the state unlawfully imprisons an individual without trial, that imprisonment is brought to an end immediately, it is detected, and appropriate compensation is paid. The second answer is defensive decision-making, but again, that could have been raised in every false imprisonment case to date from the year dot. Clearly, it is right that when the state decides to deprive a person of their liberty without trial, the decision-making should be careful. Of course it should. But there's no basis to suggest that the Secretary of State's decision-making will be unduly defensive, nor should it be. And there's no real basis to suggest that somebody who has committed a lot of wrongdoing and needs to be detained, somebody who is in who has been in that position, will ever recover substantial damages for false imprisonment, even if they do illegal error in the process, because of the proviso in Lumber about the circumstances in which damages will be awarded. And so one comes back to Mr. Nezza. Mr. N, he was imprisoned by the state without a trial for 242 days. The state is required to prove that it imprisoned him lawfully, but it can't. It can't, because it imprisoned him unlawfully on the basis of an order made by the respondent and implemented by the respondent that was unlawful, and not just unlawful, seriously unlawful, because it stripped Mr. N, a refugee, of his right to a safe haven in the UK. And it did that in breach of primary legislation, in breach of an EU directive, and in breach of the Refugee Convention. And it did so on the basis of an order that the Court of Appeal went so far as to describe as irrational in substance, not through some procedural flaw along the way, but in substance, irrational. And as far as public law errors go, in my respectful submission, this was as serious as it gets. And therefore, this is, in my respectful submission, no place to start making exceptions to all these fundamental principles that we considered yesterday. All that the state can do, realistically, is argue that in the false imprisonment claim that Mr. N now brings, he shouldn't be allowed to state the obvious, that he was unlawfully imprisoned for 242 days. Subject to any note that comes in after the case is over, they don't pretend that his way is barred because of res judicata or issue estoppel or abuse. They don't claim he's acting abusively, nor could they, in my respectful submission. They say, essentially, that it's implicit in the fact that his deportation appeal was dismissed and that he could have raised the unlawfulness of the SI in that appeal, or I suppose in a contemporaneous JR. They say it's implicit in those matters that he now should be prevented from having effective recourse to his private law right to bring a false imprisonment claim. Now, for the 9 reasons of principle we advanced yesterday, we submit that the Secretary of State's case in opposition is wholly fundamentally wrong, and that it's Kawaja that is the crux of the matter, which the Secretary of State hasn't even addressed. And we say that, in closing, the right of a subject to claim that he was unlawfully imprisoned by the state without a trial simply can't be taken away by a mere statutory implication. Only the plainest language in primary legislation could do that, and that is simply not present in the deportation appeal decisions, the deportation appeal machinery. If I may just consult with my colleagues for one moment. Unless I can insist on precedent, which I've not really come back to in
I don't think you need to.
Any further matter, those are our submissions.
Presumably you don't disagree with Mr. Tam. We should leave precedent severely alone.
Well, you would like us to say something about it.
I think where the Court of Appeal was clearly Wilson says what it says. It's the Wilson case, and the Court of Appeal seemed to be persuaded by that. They simply said, well, it's arguable. Surely it's just
I wasn't
right.
inviting you, I just recalling that you had said you'd quite like us to say something about it.
Yes.
And when would you be able to provide me with a note you very kindly offered?
Well, it's already there. I think we'd probably like to have a final look at it. So would tomorrow be?
Yes, that'll be fine. And if you want to reply to the note, Mr. Tam, you will have the balance of the week.
I'm grateful.
Right. Thank you very much indeed. Thank you.
Thank you, my lords.
We're grateful to Council for the erudite submissions in this difficult case, and to those who, behind the scenes, composed written statements and so on, and of course to the intervener for his helpful submissions, including one received this morning. We'll adjourn now, and judgment will be delivered in due course.